Welcome back to Winning Isn't Easy. Let's talk about mental nervous disability policy limitations and Lyme disease. Lyme disease is a complex multi-system illness. It's difficult to diagnose and it is complicated to treat. What's important is developing the symptoms in your medical records, and those symptoms can include chest pain, palpitations, shortness of breath, gastrointestinal symptoms, joint pain, neurological symptoms, memory issues, and even psychological symptoms. The psychological symptoms are important to develop, and they can include mood swings, irritability, anxiety, depression, and any of those symptoms can be problematic in a long-term disability claim. Why do I say that it's problematic? Well, there are mental nervous policy or plan limitations in many disability policies or plans, and they come in two flavors. The first flavor is if your disability is caused or contributed to, regardless of how small, by a mental or nervous disorder, benefits are limited to just 2 years. It's the contributed to language which is problematic. There are other version, of course, is that you have that you're disabled based on a psychological condition. And obviously, we need to be parsing what the disability policy or plan terms are that you have, because it will impact the strategy of the case. So let me give you an example. This is the case of Mateo versus Reliance Standard. It's a case out of New Jersey. And Mateo suffered from Lyme disease, chronic pain, chronic fatigue syndrome, fibromyalgia, thyroid disorder. And of course, she also suffered from anxiety and depression. It's not uncommon to see those anxiety and depression caused by multiple physical problems. Now, ultimately, Reliance terminated her long-term disability benefits after 12 months based on the plan's mental nervous policy limitation. And obviously, she wasn't happy about that. But the language of the mental or nervous clause clearly stated that benefits are not payable for disability caused or contributed to by mental or nervous disorders. So the proper question in this case with this type of mental nervous limitation for Reliance and the court is to determine whether Mateo remained totally disabled based on her physical limitations, or in other words, were her physical symptoms the symptoms that rendered her to be disabled regardless of her mental condition. Now, unfortunately for her, her medical records documented that her anxiety and depression contributed to her overall impairments. And as a result, the evidence did not allow for this parsing and support a finding that her physical condition on their own rendered her to be totally disabled. The court obviously upheld the denial of the benefits based on the language of the mental nervous policy limitation. And that was not obviously a happy thing for Mateo. Now, what I think you have to do before you stop work and apply for your benefits is to understand what your policy provides in terms of the definition of disability, occupation, and whether there are any limitations such as the subjective medical condition limitation or the mental nervous limitation, because that will drive, in my view, how the case is presented. Now, obviously, you want to get a copy of your medical records and you want to review them cover to cover to understand what your physician's opinions are about your diagnosis, whether your condition is disabling, and the extent to which any psychological problems are contributing to your overall disability. And it may be necessary to clarify through your physicians that while you may be suffering from a psychological problem like depression or anxiety, that they are not the cause of, nor are they contributing to your overall disability. And that obviously means that you've got to do some work before you're applying for benefits. We want to make sure that your medical records document that your physical problems, including your Lyme disease, cause you to be totally disabled based on your physical limitations. The goal here, obviously, is to prevent the disability carrier from using the mental nervous policy limitations to deny your benefits after 12 months or 2 years. So it obviously requires some coordination before you stop work and apply for benefits. Now, if you haven't followed that advice and you've stopped work and you're now collecting benefits, you need to understand that at some point, the disability carrier plan is going to be looking at your medical records to see whether or not they can apply that mental nervous policy limitation or even a subjective medical condition limitation, as I've discussed in earlier episodes. If the policy language is caused or contributed to, I think that you need to determine whether or not, in fact, your depression, anxiety, or your psychological problems are contributing to the disability, and whether or not you would be disabled with or without those mental or psychological problems. If those problems are there and you're getting treatment and they're not disabling, I think your medical records need to make that abundantly clear. Also, your medical records need to make it abundantly clear what your symptoms are from a physical standpoint and how those symptoms prevent you from doing your own occupational duties or the occupational duties of any other occupation. Because the disability carrier is going to parse those medical records and look for reasons to deny the claim. So you need to start making sure that your medical records are accurately telling the story of your symptoms, how they're disabling you, why your psychological symptoms or problems are not contributing to your disability, and why your physical conditions, symptoms, manifestations of any disease, including Lyme disease, are in fact why you are disabled. You can see it takes a lot of work, and that's just one reason why you want to have an experienced ERISA disability attorney. If you've got a disease like Lyme disease, Epstein-Barr, chronic fatigue syndrome, disability carriers look very closely at these claims in an effort to either deny them or to terminate benefits based on the mental nervous policy limitation or subjective medical condition limitations. Got it? I hope you have enjoyed this week's episode of Winning Isn't Easy. I hope that you've enjoyed it, and you've enjoyed it so much that you're going to like our page, that you're going to leave a review, you're going to recommend it to your family and friends. And of course, you're going to subscribe. I look forward to talking with you in our next episode of Winning Isn't Easy. Thanks.
Have you been robbed of your peace of mind from your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claim process. Request your free copy of the book at caveylaw.com today.